by virtue of employment as a member of the National Assembly for the Umkhonto weSizwe political party, situated at 120 Plain Street, Cape Town, with effect from August 2024. I also reside at Acacia Park Parliamentary Village during parliamentary sessions, which is situated at Townsend Street, Goodwood, Cape Town. 3. I'm an accused in the criminal matter pending before this Honourable Court, as per charges delineated in the charge sheet and the applicant herein. 4. The facts deposed herein fall within my personal knowledge and belief and are true and correct unless the contrary appears or the context indicate otherwise. 5. Where I make submissions of law, I do so on advice of my legal representative, which advice I verily believe to be correct. 6. I attest hereto solely in the application to this Honourable Court to be released on warning, alternatively on bail, should the Honourable Court be so minded. 7. I intend tendering a plea of not guilty on all the charges preferred against me at the commencement of my trial, and submit that the evidence against me, both in this and the Moodley matter, in brackets, S versus Kuberethni, Moodley and 12 others, case number SS 76 of 2023, close bracket, is with respect extremely weak to being non-existent, and I endeavor to challenge same vigorously. 8. I am advised that the charges preferred against me fall under the ambit of Schedule 5 of the Criminal Procedure Act 51 of 1977, in brackets the CPA, and I am required to, in accordance with the legislative framework, more specifically Section 60, subsection 11, subsection B of the Criminal Procedure Act, adduce evidence which satisfies this Honourable Court that the interest of justice permits my release, having been afforded a reasonable opportunity to do so. I address the aforestated prerequisites further below, but first deal with the salient background facts relevant to this application and for the benefit of this Honourable Court. I then go on, Your Worship, to deal with a brief background. Paragraph 9. I presently stand indicted in the Gauteng Division of the High Court, Johannesburg, as accused number 11 in the matter of S versus Moodley and 12 others, case number SS 76/2023, the Moodley matter, which matter is set down for trial from the 2nd day of February 2026. 10. The Moodley matter is the subject of investigation by the Investigating Directorate Against Corruption, in brackets IDEC, i.e. the second respondent herein, and who has at all material times represented the state in these proceedings, in brackets including at its capacity as the Investigating Directorate, in brackets ID, of the National Prosecuting Authority, as it was previously known, under Johannesburg Central Case number 465/10/2019. To my knowledge, the investigating officer at all material times has been Lieutenant Colonel Denwil Reginald Kutsia. Paragraph 11. I was arrested in relation to the Moodley matter on 22 August 2022 after receiving a telephone call from Lieutenant Colonel Kutsia, in which he requested that I hand myself over on the morning before my scheduled court appearance before this Honourable Court, albeit differently constituted. I was subsequently arrested, charged and admitted to bail on the self-same day. The state, as represented by the second respondent, did not oppose my bail, notwithstanding the matter falling within the ambits of Schedule 5 of the Criminal Procedure Act. 12. I was admitted to bail and understood my bail conditions as follows. 1. That I pay an amount of 50,000 rands as security, which amount I paid. 2. That I hand over my passport to the investigating officer, Colonel Kutsie. 3. That I am not permitted to travel outside the jurisdiction of South Africa without the permission of the investigating officer, which permission should not be unreasonably withheld. 4. That I provide my detailed travel itinerary to the investigating officer, who will return my passport for the purpose of international travel. 5, that I attend all my court appearances until the matter is finalized. Paragraph 13, I have since attended all my court appearances in the Moodley matter as directed by the Honorable Court. I have also, at all material times, fully cooperated with the second respondent. 14, with the acquiescence of the second respondents who temporarily released my passport, I traveled outside the jurisdiction of South Africa to Tanzania on business from 24 February 2024 to 2 March 2024. Upon my return, I returned my passport to the investigating officer. 15, I stand indicted on the following charges in the Moodley matter as per the most recent indictment dated 28 January 2025 and which is signed by the head of the second respondent, Advocate Andrea Johnson, a copy of which is enclosed herewith for the convenience of the court. 15.1, counts 1 to 8, fraud read with the sections of sections 103, 256 and 257 of the CPA in relation to the amount of 36,763,000. Alternatively, theft read with section 256, 257, 264 and 332 of the CPA in relation to the same quantum as the main counts. 15.2, count 9, fraud read with sections 103, 256 and 257 of the CPA in relation to an amount of 79,230,000 rands. Alternatively, theft read with section 256, 257, 264 and 332 of the CPA in relation to the same quantum as in the main count. 15.3, count 10, fraud read with sections 103, 256 and 257 of the CPA in relation to an amount of 189,240,000 rands. Alternatively, theft read with section 256, 257, 264 and 332 of the CPA in relation to the same quantum as the main count. 15.4, count 49, contravening section 86 in brackets 2, read with sections 1, 2, 3, 48, 50, 51, 55, 56 and 76 of the Public Finance Management Act 1 of 1999 in brackets the PFMA Act, read with sections 84 in brackets 3, section 256, 257 and 332 of the CPA in relation to an amount of 36,763,000 rands. 15.5, count 50, contravening sections 86, subsection 2, read with sections 1, 49, 50, 51, 55, 56 and 76 of the Public Finance Management Act, read further with sections 84.3, 256, 257 and 332 of the CPA in relation to an amount of 79,230,000. Paragraph 15.6, count 51, contravening section 86, subsection 2, read with sections 1, 49, 50, 51, 55, 56 and 76 of the Public Finance Management Act, read further with sections 84.3, 256, 257 and 332 of the CPA in relation to an amount of 189,240,000 rands. 16. The charges preferred against me in the Moodley matter ostensibly relate to the period when I served as the Group Chief Executive Officer at Transnet SOC Ltd, in brackets Transnet. and per the indictment relates to the period from April 2012, when Transnet launched the Market Demand Strategy, MDS, in achievement of South Africa's broader socio-economic objectives, which inter alia entailed creating value for Transnet through increasing the tonnage delivery and in shifting from road transport to rail transport, so to enhance the environmental footprints and job creation in relation to the procurement of the transaction advisory services for the 1,064 locomotives acquisition tender through a confinement process up to period June 2015. Paragraph 17. In paragraph 11 and 14 to 17 of the summary of substantial facts to the respondents inter alia, or rather the respondent inter alia assessed the following. I quote paragraph 11. On 7 May 2012, Gary Peter, accused number 5, submitted a memorandum to Brian Molefe, accused number 11, requesting approval for the appointment of service providers for the provisions of transaction advisory services related to the 1,064 locomotives acquisition tender through a confinement process. 14. According to the memorandum, the appointment of transaction advisors by way of confinement was solely based on the ground of urgency and was set out as follows. 14.1. The 1,064 locomotives were part of the plan to fulfill the MDS. 14.2. To meet the MDS, I beg your pardon, Your Worship. 14.2. To meet the MDS and corporate plan targets, the first tender was to be awarded in November 2012, and 14.3, as a result, Transnet had to immediately source transaction advisors to assist with all services required in pursuance of the 1,064 locomotives acquisition. 15. On 10 May 2012, Brian Molefe, accused number 11, approved the confinement process. 16. On 30 May 2012, Transnet issued a request for proposal in brackets GSM/12/5/0447 close bracket RFP for the appointment of transaction advisory services related to the procurement of the 1,064 locomotives. 17. On 26 July 2012, Transnet appointed McKinsey Consortium as transaction advisors to provide advisory services related to the acquisition of the 1,064 locomotives, I close quote. 18. In paragraph 77 to 92 of the summary of substantial facts, the respondent asserts the following. I quote paragraph 77. On 17 March 2014, Transnet awarded a contract to 4 bidders for the acquisition of the 1,064 locomotives at a value of 54.5 billion rands with the following original equipment manufacturers, in brackets OEMs. 77.1, China South Rail, 359 electric locomotives. 77.2, Bombardier Transportation, 240 electric locomotives. 77.3, China North Rail, 232 diesel locomotives. 77.4, General Electric, 2333 diesel locomotives. Transnet planned to finance the 1,074 locomotives acquisition by raising debt, that is, obtaining loans. At the time, Transnet had a well-established treasury department comprising individuals with various specialized skills. 79. Transnet's treasury commenced with a funding strategy which was aligned with the board's approval strategy for the Transnet group of companies and the financing component for the 1,064 locomotive acquisition, which was divided as follows: 79.1, the China Development Bank loan; 79.2, the club loan; and 79.3, the interest rate SWAPS. 80, the proposed funding arrangement for the Bombardier transport component was done through Export Development Canada, and the General Electric component was done through the Export-Import Bank of United States. 81, on 29 April 2014, Ms. Makhatu wrote a memorandum to Brian Molefe, accused 11, and Anoj Singh, accused 12, to request approval for the Transnet Group Treasury to proceed negotiations with the China Development Bank for the funding of the China South Rail and China North Rail components. Anoj Singh recommended the request and Brian Molefe approved it. 82, in May 2014, Transnet Group commenced with the negotiations with the CDB regarding the financing of the locomotives to be procured from the Chinese suppliers. 83, during the post-tender negotiation phase, Regiment's Capital became involved in the negotiations on the CDB loan on instructions from Anoj Singh, accused 12, to assist Transnet Group Treasury. 84, Ms. Makhatu resigned as Transnet Group Treasurer effective on 30 November 2014. After her resignation, the negotiations between Transnet and CDB came to a halt because of certain issues regarding the financing terms that could not be agreed. 85, on 1 March 2015, Petulo Ramusebudi, accused 7, was appointed as Transnet Group Treasurer, and the negotiations with CDB were revived by Eric Wood, accused 3, on behalf of Regiment's Capital. 86, on 16 April 2015, CDB sent an official mandate letter to Transnet that set out the terms and conditions on which they were willing to arrange the loan facility to $2.5 billion for Transnet to fund the acquisition of the 232 diesel locomotives and 459 electric locomotives. The letter provided indicative terms for the loan facility and formed the basis of the agreement between Transnet and CDB. 87, Brian Molefe, accused 11, signed the mandate letter on the same date, paving the way for Transnet to obtain a loan from CDB on less favorable terms than what could be obtained from other financial institutions. 88, on 17 April 2015, the former Minister of Public Enterprise announced that Brian Molefe, accused 11, was seconded to ESCOM with immediate effect. 89, on 28 April 2015, Petulo Ramusebudi, accused 7, compiled a memorandum to the Acquisition and Disposal Committee, which motivated the appointment in confinement of the J.P. Morgan Chase Bank, in brackets J.P. Morgan, and Regiment's Capital, accused 10, to conclude the CDB loan. The memorandum was recommended by Siyabonga Gama, accused number 4, Gary Peter, accused 5, and Anoj Singh, accused 12. 90, the recommendation requested for the ADC to approve the following. 90.1, the confinement appointment of J.P. Morgan to hedge the financial risk emanating from the $1.5 billion CDB loan back to South African rands. The confined appointment of J.P. Morgan to lead and underwrite the equivalent syndicated loan of $1.5 billion. 90.3, the contract extension from 99.9 million rands to 265.5 million rands for the appointment of Regiment's Capital, accused number 10, for transaction advisory services and support to Transnet on the 1,064 locomotives and 90.4 delegated authority to Siyabonga Gama, accused number 4, to approve all documentation related to the confinement. 91, the request was approved by the ADC on 29 April 2015, and Anoj Singh, accused 12, was present in the board committee meeting. Anoj Singh failed to inform the members of the ADC that 91.1 Transnet Treasury team did most of the early negotiations. 91.2 the terms and conditions of the CDB loan were not favorable to Transnet, and 91.3 Anoj Singh did not notify the board about the exorbitant arrangement fees and interest that would cost Transnet an extra 3.7 billion rands over the loan duration. 92, on 3 June 2015, Regiment's Capital, accused 10, delivered an invoice to Transnet for a success contingency fee on their work towards the CDB loan, totaling 189,240,000, VAT included. 93, the CDB loan was signed on 4 June 2015, I close quote. Paragraph 19, paragraphs 101 to 112 of the indictment canvasses the $1 billion club loan and or 12 billion South African rands loan facility for the purpose of locomotives and respective of roles of inter alia Daniel Roy and Trillion Capital. 20. The second respondent is required to prove all of the above as it asserts in the indictment against some of my co-accused and I, who also now accused before this court. The above allegations contained in the second respondent's indictment against me relate specifically to the extent charges preferred me in the Moodley matter, and are moreover intrinsically linked to the new charges which the second respondent has decided to now prefer against me. 21. I was surprised to learn that the prosecutor in this matter, Advocate Santosh Minlan, who is also the prosecutor in the Moodley matter, called my attorney of record and advised that a decision had been made to charge me in relation to the acquisition of the 95, 100 and 1,064 locomotives. The ostensibly new charges are so intrinsically linked that any prosecutor or investigating officer acting rationally and reasonably would have added new charges against my co-accused and I in the Moodley matter, as opposed to initiating new charges against us, which are founded on the same factual and evidential matrix as the Moodley matter, and would, in the main, require many witnesses already listed as witnesses in the indictment in the Moodley matter. 22. Furthermore, in specific reference to the acquisition of the 1,064 locomotives, the Johannesburg High Court had in April 2025 set aside the decision of Transnet of January 2024 of 24 January 2014 awarding GE South Africa Technology Pty Ltd, known as Webtech South Africa Technologies Pty Ltd, the supply of 233 diesel locomotives and the locomotive supply agreement dated 17 March 2014. Notwithstanding, the High Court made a just and equitable order in confirming a settlement agreement reached between Transnet and GE South Africa Technology Pty Ltd as early as 8 November 2019, in brackets, and which was amended on 18 November 2022, I close bracket, to the effect that Transnet would retain the 233 diesel locomotives delivered by GE South Africa Technology Pty Ltd to Transnet pursuant to the locomotive supply agreement dated 17 March 2014, along with a settlement amount of 70,350,574 rands, whilst Webtech South Africa Technologies Pty Ltd would retain all amount Transnet had paid to GE South Africa Technology Pty Ltd under the locomotive supply agreement dated 17 March 2014.
I submit, Your Worship, to consider.
Your Worship, there's just one issue. I've taken note of condition 1.4. My understanding has always been that the police and the state works as a team. Now, to now take the passport from one investigator and hand it to another investigator is a bit supercilious. I submit that it be detained either by the NPA or by the investigating team, whoever it is in this matter. It just, at the end of the day, is going to cause a lot of confusion as to if you want to go and ask for instance, to travel, who has it? Indeed.
Once the matter is finalized, the current matter that's going to go on the second day of February is finalized. Those, and this one has not as yet been, you don't even have a time. Those passports would move from the investigating officer of the first matter to the current investigator in this matter. So it makes sense.
Ask the court, please.
Really, this matter is what is supposed to be said. The state has considered that you have two candidates to the play. If one looks at paragraph 11, which follows just referred to, stated as follows. There is no reason to believe that the accused is engaged, would endanger the safety of the public or any specific person. There are no reasons to believe that the person that the accused will involve the trial, and there are no reasons to believe the person that the accused will intimidate or influence witnesses, or that they will destroy evidence. And lastly, there is no reason to believe that the person that the accused will undermine or jeopardize the criminal justice. On this basis, bail is granted and fixed as follows. Accused number 1 is to pay bail in a cash deposit amounting to 50,000 rand. Accused number 2, bail is fixed in a cash deposit of 50,000 rand. Accused number 3, bail is fixed in a cash deposit of 50,000 rand. And accused number 4, bail is fixed in a cash deposit of 50,000 rand. The reason why the court does this is because they've already been made themselves exemplary citizens of the country. They pay bail in respect of a matter related to this, not specifically a repetition of that matter. And they have, at the court, had ordered that if they want to leave the republic, they should apply, and they did apply. They granted their passport, and true to their word, they came back to South Africa. So there is no reason whatsoever, because there is no reason whatsoever without the credentials. Their conditions are as follows. Should be ended over 2 days. All 4 of you are not to apply for new passport or travel documents until the final decision of this matter. Should you wish to travel abroad, the formal application has to be lodged. And lastly, once the matter that's going to commence in the report on the 2nd of February 2066 is finalized, the investigating officer in this matter is to demand your passport to be current investigation. investigation officer in this matter. So this order is actually directed to the investigation officer, not to you understand. I mean, I just made a switch.
Your Worship, unfortunately, we have not had the chance to canvass a suitable date or agreeable date between the parties and Mr. Bolfa. Your Worship, if we are able to get Mr. Bolfa to check his diary, within the next 15 minutes we'll be able to.
That's fine. We'll adjust.